Good morning, good evening, hello and welcome to the second of our webinars where we'll be discussing the results and implications of Taylor Wessing's fifth global IP index known as GIPI 5, which we launched earlier this year. This webinar focuses on the results and analysis for the Asia and ASEAN region. My name is Mark Owen and I'm an IP and media partner based in London and one of the editors of the GIPI, and with me will be Roland Mallinson, also based in London, who is the main editor. For those who don't know Taylor Wessing, briefly on that, we're a full-service international law firm with 1,200 lawyers servicing primarily IP-rich industry sectors in 18 jurisdictions across Europe, Asia and the Middle East, with representative offices on the west and east coasts of the US. And the slide provides a little more information about the firm. And as you'll see, the reach we've got lends itself well to a global survey of this sort. The topics we are covering in today's session are listed on the next slide. I will begin with a very brief introduction to the GIPI 5 report. If you wish to hear more about GIPI in general and have an overview of the overall results, then the thing to do is to listen to a recording of our June webinar, which is available on our website, and a link will be available. Our panel today will then discuss the results for jurisdictions in the Asia and Asian regions, which will take, we would think, about 45 minutes altogether, depending upon questions. If you would like to ask questions of our panel, then that's easy to do. There is a Q&A box that should be available on your screen. Please simply submit them and press the button, and we will aim to answer those if there's time at the end. But please do submit any questions you want. And also, one further request is, would you please submit any feedback on the webinar using the survey button, which again you should be able to see on your screen within the webinar system. It's incredibly useful to get your feedback so we can make these sessions useful and tailored to your needs. The next webinar in the series will be looking at the EU and also considering the elephant in the room for many of us, which is the implications of the UK's vote to leave the EU, the so-called Brexit. So I'd like to introduce the panel with me today. So apart from me, Mark Owen, there's Roland Mallinson, and then in various locations across Asia. First we have Jonathan Koch, who is an IP partner in RHT Law, Taylor Wessing in our Singapore office. Then Thomas Patlock, who is the partner who heads our China IP practice. And then Pavani Banyamisara, an IP partner in Taylor Wessing's associated Thai law firm, Chavalit and Associates Limited. And there are links to our profiles at the end of this. So I'd like to start by explaining what the GIPI is. As I say, we're now in our fifth edition. The GIPI aims to be a comprehensive assessment of the IP regimes of the major financial centres and trading countries around the world. We base it on a survey with over 8,500 individual country assessments, which we combine with what empirical data is available, such as the number of patents or trademarks filed, sources of counterfeit goods seized by customs, that sort of thing. The 43 countries we ranked this year are rated and ranked for each of the main four families of IP rights, patents, trademarks, designs and copyright. And we also extend into a non-IP section, I suppose, dealing with data privacy. And the report then analyses the results in the light of legal developments in each country. So, with that background, let's go to the nitty-gritty and what's happening on the ground in the various jurisdictions. Now, unsurprisingly, perhaps, China's always a favourite topic of conversation when it comes to IP rights among clients and lawyers, and in GIPI 5 China was ranked 39th out of 43. And what we plan to do first is do a general overview of what we've seen in China in the last 18 months, and I wonder if I could hand over here to Thomas Patlock to give us your views. Thomas, please.
Yes, thank you, Mark, and welcome everyone. we believe that the Chinese government in the period between the last GIPI and the current GIPI has made some significant efforts to further improve the IP regime. I will mention a couple of them. For example, on the legislative side, the scope and intensity of protection of IP rights overall has been actually enhanced. In the past 2 to 3 years, the trademark law, the implementing regulations have been revised and have entered into force as of May 1, 2014. In the patent area, graphical user interfaces now can enjoy protection under Chinese design patent law. And to battle the ever-increasing number of infringements taking place on the Internet, the State Administration for Industry and Commerce implemented new measures for the administration of online trading in March 2014, followed by further local regulations. In the area of patents, if you look at the developments there, the State Intellectual Property Office issued new measures for administrative law enforcement in connection with patents. And that strengthened the authority of Administrative IP Bureau to enforce patent rights. And this trend for strengthening remedies and sanctions against infringers continues in 2016 on the patent side. Interestingly enough, not so much on the trademark side. There we actually see a drop in numbers. I'll come back to that later. We see, therefore, for the patents, local authorities becoming much more active and involved in infringement cases. And the Supreme People's Court has also just recently issued new judicial interpretations on the infringement of patent rights. In these interpretations, the principles of how to determine patent infringement have been clarified, and one important issue for right owners, the liability for contributory infringement, has been really greatly increased and improved. Concerning the Internet and copyright protection, possibly the most pressing and most difficult area at the moment in China, in conjunction with campaigns like SwordNet 2015, which targets online piracy, a significant number of administrative rules and regulations targeting inter alia also copyright infringement have been issued, such as the opinions on strengthening control of infringement and passing off in the Internet, which was issued by the Almighty General Office of the State Council. These opinions target new transmission methods, such as third-party applications of smart mobile terminals, cloud storage spaces, Weibo, Weixin, WeChat, and makes them subject to copyright oversight. On the other hand, however, the copyright law itself, the revision of it, has not advanced further and appears to be stuck due to a deadlock of differing opinions by multiple agencies involved, competing for competencies in the area of publishing, online services, and copyright protection. And in spite of many calls, also no trade secret protection law has yet been passed, a topic which has been recently intensively discussed with the US government and the EU Commission. The much anticipated revision of the anti-unfair competition law, ongoing now since a decade or so, has produced a new draft in the recent past, but not yet led to a passing of a new law. On the other hand, what is interesting to observe is, in spite of the low ranking, the use of the Chinese IP system has intensified over the past years. In 2015, more than 2.6 million trademarks in 1 year have been filed, in comparison to about 1.6 million 3 years before. And in the area of patents, which includes utility models and designs in the form of design patents, more than altogether 2.7 million applications were filed in 2014. In 2015, we saw 1,102,000 patent applications for inventions, which is an increase of over the year before of more than 18%, and 263,000 invention patents granted in that year, which is an increase of 61%. In relation to enforcement at the end of 2014, this is something which is rolling out now since 2 to 3 years. A new IP court for IP-related cases has been established in several cities in China, namely Beijing, Shanghai, and Guangzhou. And the number of IP-related court disputes continues to rise and has broken the ceiling of over 149,000 IP cases, including administrative cases, newly filed in 2015. We note, however, that in particular in the area of trademarks, enforcement actions by administrative authorities on behalf of foreign right owners have significantly dropped since 2011 and have reached almost only half of the number of about 17,000 enforcement cases in 2011. So enforcement appears to be concentrated in the eastern part of the country, and varies in its efficiency depending on where a lawsuit is raised, and to some extent also by whom a complaint is filed. Finally, in the very important area of competition law, on April 7, 2015, the SAIC finalized provisions for the prohibition of acts for abusing intellectual property rights to eliminate or restrict competition. According to these provisions, which will become more and more important in the future, prohibited practices include unreasonable exclusivity discrimination, tying and bundling of patents, and refusal to license patents under certain circumstances, the prohibition of exclusive grant-back provisions in license agreements, non-challenge clauses and royalties for expired patents, and the big elephant in the room of patents, the use of standard essential patents, and including questions of a patent ambush or unreasonable refusal to license. These new rules, together with a decision to punish the U.S. patent holder Qualcomm for abuse of IP rights, may have also contributed to an overall more negative rating of the Chinese IP system as such. So all in all, courts and agencies are very active, and the system is getting used more and more, particularly not only by foreign right holders, but very increasingly by Chinese. But the written law lacks, however, transformation into tangible actions on the ground, especially in the western part of the country still, and there's therefore a desire that efficiency may still have to be improved and that the predictability of the system needs also to be increased. With that longer introduction, I'll give back to you, Mark.
Thanks, Thomas. So from what I'm hearing, it sounded like it was something of a mixed bag, that progress in terms of introducing new laws, new procedures, but perhaps less progress in terms of actually then enforcing it or it being something practical that rights owners can rely on, particularly in the east of in the west of the country.
Yes, right, that's it.
Okay, and which direction do you think things are going to carry on from here? Do you think that things will improve for rights owners and there will be further change, or are we likely to see things stopping now?
Yeah, we expect that in the coming years, the case law will becoming more and more important and will have to be watched for companies, because as enforcement is kind of patchy and it's very local. In particular for patent enforcement, it needs to be very clear what requirements each region will put up and how the requirements under the law will be interpreted. And in trademark and copyright cases, recently in cases directed against unfair competition against Baidu for illegitimate advertising, also further changes will come along. But all in all, while the system is changing, the drop in rankings in our view are mostly a result of the difficult task of still transitioning the economy to a more IP-compliant economy, and on the other hand, maybe a still perceived need by the Chinese government to intervene much more strongly in issues such as perceived anti-competitive behavior by IP right owners. So fundamentally, the system in terms of legislation continues to improve. Higher damage awards are granted, statements are issued by the IP court and the SPC. So that may move up the perception that the system is getting better. But the challenge will really be to get things done on the ground, and I understand that also Jonathan has some experience to share with us in this regard.
Yeah, that's right, Thomas. Our own experience is that whilst we have seen China taking steps to update their IP laws as well as introduce an IP court, the real question and concern for our clients is how these laws are translated to ground-level enforcement. And our experience is that enforcement action is really not consistently applied throughout China. What our clients typically find is that they may find the infringing goods being sold in major cities like Beijing, Shanghai, Shenzhen, and Guangzhou. And again, these are the major cities in the eastern coastal area. But production and manufacturing is usually done in the smaller provincial towns. So you do need to get the cooperation of the administrative bodies, such as the Administration for Industry and Commerce, to assist in enforcement in the smaller provincial towns. But in these places, they're not as well staffed with officers, and neither do they have the high respect for IP as you may find in the bigger cities. So what we really hope to see in the future is that the government will will get the agencies in the smaller provincial towns to raise that same level of commitment to fight copyright or trademark infringement, because for our clients, fighting infringement at source is really what is key to them in combating the infringement actions in China.
Right. Thank you, Jonathan. Thomas, China was ranked fairly low for trademarks, second from the bottom of our survey. And one reason for this is presumably the ongoing problem of bad faith, opportunistic applications. How do you suggest businesses protect their brand from this sort of behaviour?
Yeah, I mean, this is a problem which is really not solved and which now moves towards the new issue of Chinese language trademarks. That there were many hopes put into the revision of the trademark law in 2014 that something more concrete would be put into the law to define what is bad faith. But the key issues were actually dodged, and there was nothing provided for very tangible under the trademark law. And we believe the survey mirrors this in the number of comments on the insufficient body on clear IP laws. And another issue which is becoming increasingly difficult for people to deal with is this burden of proof and the evidential requirements. Many Asian countries have high evidential requirements. Formats always play a huge role. But in China, the burden of proof is really, really very challenging when it comes to bad faith. So it will not be enough just to cite 20 other applications of other people's trademarks to prove bad faith. You will have to come with much more. And as one right owner put it, a real headache for right owners remain the excruciatingly high burden of proof, including on bad faith applications and own reputation in the market. End of quote. And this is really what mirrors the concerns and problems that everyone has. And our advice to right owners is it's a very classic advice. Register as early as possible, as broadly as possible. Don't rely on unregistered trademarks. They do not protect you unless you achieve the status of a well-known trademark, which is very, very hard to achieve today. And monitoring is key to prevent pirates to gain ground. There is a new legislative and also jurisdiction-wise a development in case law which grants coexistence rights to aggressive infringers who manage to become well-known in China by themselves or to obtain their own reputation. And there is case law developing in this which makes it very hard if you don't follow up on an infringer early, and you risk that actually another party will gain a right to coexist even though it may have infringed your right earlier on. So you need to have an assessment how dangerous is an individual or a company filing for my trademarks. And also you have to have a view at, will it enforce this trademark against me? There's this famous Xin Bailun or New Balance case in China where you can see that the liability can be excruciatingly high, can be very, very unpleasant, and can pose big problems for companies to do business in China. So right holders need to closely watch infringers. They need to watch the developments, not to be caught unaware. And for me to conclude this advice and to give an example is the OEM manufacturers, which at the moment are free to produce if their trademark is not registered in China as long as they export to a country where they have a trademark registered. But this is just case law, and the Dongfeng case recently decided shows that there's a lot of dispute among Chinese courts and it can change. So again, register your rights, defend your rights, and you'll have to invest into this area of trademark protection in China in order to really make it. Back to you,
Yeah,
Mark.
okay. Thanks, Thomas. I had just one last question before we move off China, which is, and you talked about this a little bit in your bit as well, which is about the amount of IP litigation there is, and I think there's something like 149,000 cases annually now, 24,000 trademark cases. And I was going to ask you about the trend in that, but I think you said that the number of trademark cases is possibly on the decline. Is that just a short-term blip, or, I mean, what do you think is going to happen in the future?
I mean, we will have a split. What we see now, there's this administrative enforcement route in China where you can choose to go administrative authorities, and that is declining dramatically. The authorities no longer get a reward if they deal with cases. They're getting more cautious, getting more sued by themselves. So this is a trend where we see retreating enforcement numbers by the AICs. But in the courts, especially for infringement actions, these case numbers are going up 13% over 2014 last year. And interestingly enough, we see the administrative actions, so fighting TRUP in court when the trademark is not granted or a cancellation action has not been successful, we see that retreating as well. So infringement actions in court asking for damages is getting more and more, and we believe that this will continue and will mean that right owners need to be prepared also possibly to act as a defendant in the future if they have not secured their trademark rights in China.
That's great. I mean, it's slightly awesome and awe-inspiring, but it sounds as though there's some positive direction, at least for rights owners. So at this point, thank you very much, Thomas, and also Jonathan, for comments on China. We're going to pass over to other countries in Southeast Asia, and at this point I'm going to hand over to my colleague Roland Mallinson, who's the main editor of GIPI 5, to lead the questioning. Roland.
Thank you, Mark. Yes, Singapore is the highest-ranked Asian country in both GIPI 4 and GIPI 5 reports. Jonathan, what do you think it is about the IP regime in Singapore that sits above the other countries in the region?
Yeah, it is true that Singapore has a robust IP regime, and our laws are up to date, on par with those in the developed countries. But I think what is the real driving force is the Singapore government, which recognizes that protection of IP is one of the key factors that will attract foreign companies to locate their regional offices in Singapore. So having a robust IP regime that is both current and up-to-date, and that can be relied upon when your rights are infringed, this gives assurance to the foreign companies that their IPs, whether trade secrets or their patented products, would be protected should something go wrong. And I think another crucial factor is that we've had a deliberate policy to ensure that our consumers can easily obtain genuine products at reasonable and competitive prices. So there's no incentive for consumers here in Singapore to purchase counterfeits. So if you look at our cases, reported cases, there are very few suits on counterfeit claims in Singapore. So I think for this reason, Singapore has been consistently ranked amongst the top jurisdictions in Asia for its IP protection regime. So, and that's also reflected in the GIPI 5 report.
Thanks, Jonathan. So we had a number of new Asian countries in the index this time. Some fared well, such as Malaysia, others, such as Taiwan, less so. Starting with Pavini, I'd like to ask each of you, why do you think this is?
As IP became more important in the trade, IP protection is a key feature in development of the business. You know, in view of this, the country in the region are taking big steps in having adequate IP protection. The country like Thailand and Malaysia, they work many ways to ensure that the IP protection meets international standards in order to bring in the investor into the country. And also they are constantly making sure that the IP is adequately protected for the for foreign investor and the local business as well. But comparing Malaysia with Taiwan, I would say that Malaysia has a higher level of English understanding compared to Taiwan. That's this being the case that examiner sometimes get wrong interpretation or translation of the word using the marks, and that cause difficulty in obtaining the IP and trademark protection somehow.
Well, thanks, Ravina. I mean, that must be frustrating. So, Jonathan, what's your experience on these other countries?
Well, my observation here is, firstly, some of the Asian countries are starting from a lower base. So take, for instance, countries like Myanmar or Cambodia. They are only beginning to introduce IP laws into their statutes. So you'll see more progress in IP ranking for these countries in the future as they begin to develop and they begin to recognize the IP rights of the rights owners. But in the case of Malaysia, of course, it's one of the more developed countries here in Southeast Asia, and they have been updating their IP laws and extending it to include the protection of personal data. So in 2013, they introduced the Personal Data Protection Act, and that has now come into force since 3 years ago. And they have also taken measures to improve their IP registries by introducing electronic registration systems and made their registration procedures more efficient. So I believe as Asian countries continue to develop and recognize the importance of protecting the rights of IP owners, we will see more Asian countries climbing up the IP rankings. So that's something to look out for in future GIPI reports.
Thanks, Jonathan. Thomas, what's your view from China or the other Asian countries?
Well, I'd like to make a comment for Malaysia, because Malaysia, as in China, offers the opportunity to register copyrights. And the ranking for Malaysia, for example, provides a particularly positive judgment on copyright protection, because it's possible to voluntarily register the copyright in Malaysia, subject to being a citizen or permanent resident, or you have to entrust an authorized representative. But in cases of piracy or IP infringements, copyright owners can file complaints with the enforcement divisions of the Ministry of Domestic Trade, Cooperatives and Consumerism, and alternatively can also resort to civil litigation. And another feature which runs in parallel to China and also to Thailand, which also has an IP court, is Malaysia since 2007 established dedicated IP courts as the session courts, also at the high courts, in several high courts that sit in each state handling criminal and civil cases on IP respectively. So I think that, together with that, different to other Asian countries, criminal enforcement in Malaysia and customs seizures are also perceived by the interviewees to be working in some cases quite well, may have contributed to an overall more positive rating for Malaysia.
So if we turn to Thailand, Pavini, we noticed that Thailand's been staying fairly steady in the rankings between GIPI 4 and GIPI 5. Do you think there are any major changes on the horizon which might change us in future?
Yes, actually, Thai government, they've tried to improve a lot in this area to ensure that there is adequate protection for IP in the country. The Trademark Act was amended, among other issues, they expanding protection to the sound mark and acceding to the Madrid registration system. The Patent Act is, being reviewed for amendment in order to facilitate the patent registration process. The Copyright Act was amended to provide broader and advanced measures to combat the copyright infringement, in this digital era. And the Custom Act was also amended to clarify and detailing the custom procedure for the transit and transshipment of the goods. And with these, the significant amendment, we hope that Thailand will be better, equipped to, handle all the counterfeit products in the country and able to offer the better IP protection for both, local business and foreign business. Yes, that might be.
We've all mentioned counterfeiting a bit, I think, through this. Certainly it was identified by respondents as an ongoing problem. I think in the region, particularly the online platforms such as Taobao, Alibaba and JD.com, these are particularly enabling sales directly from the manufacturers to consumers across the region. This is a question for each of you. How do you think the laws and courts are coping with this, and what can brand owners do to tackle it in the region? Jonathan first.
Yeah, it is clear that many e-commerce sites have sprouted across Asia in the recent years, and I think this is really because Asia has one of the highest mobile device penetration rates. So everything is done online, and many of the consumers are going around with mobile device, and they'll use it to transact online. So, but the downside of this is that counterfeiters have also taken to selling counterfeit goods online. So it's important that governments in Asia update their IP laws to cover online sale of counterfeit goods as well. And some of the, and maybe, on the part of the consumers, or rather on the part of the rights owner, they can also take practical measures. And if you look at some of the bigger e-commerce sites, what they've done there is that they've also introduced complaints procedures where they undertake to investigate complaints of infringement, and they will take down a site that blatantly sells counterfeit goods. So in our experience, we've assisted a number of clients to file such complaints to the online market platforms, and we've seen some measure of success. So as a first step to fighting infringing activities, really on the online arena, we advise that you should consider writing to the e-commerce company to lodge a complaint. But of course, that's only tackling the symptoms and not the source of the problem. Eventually, you still need to go against the infringers where they're located. And that's something we discussed earlier about enforcement against infringers in China.
Yes, I'll come to Thomas in a moment. Pavini, first, also, how about dealing with these online threats in Thailand and the area?
Actually, the Thai government, is well aware of this problem in Thailand, and they made several moves to develop better system to protect the brand owner. The sample of this is the monitoring of the good at the border. As I said earlier, they did amend the Custom Act so that they have a clear procedure to handle the good in the transit and the transshipment. The strict measures are taken to ensure that the counterfeit products are stopped at the border. The custom software program also developed to facilitate the recordation of the border protection. The law firm like us play important role in this aspect. We had meeting with them, and we discussed and comment what we and the brand owner expect from this development. And I would say that the government tries so hard to create a secure and safe environment to the brand owner to have adequate IP protection for their business in this regime. And I would recommend that all the brand owner, they record, their trademark with the custom for the effective, border measures protection.
Thank you, Pavini. Thomas, so do all roads lead to China here, and how is it being dealt with in China?
Yeah, I'm afraid that this is really an issue in China which is not going to go away quickly, because actually the online platforms are the best distribution channel ever for counterfeits and are used widely, as has been confirmed by the Chinese government itself in many reviews of Taobao on JD.com and other platforms. While the official figures were very positive, sometimes 20, 30%, the more likely number goes up to 70% in some cases. So what has happened is the government has put pressure on Alibaba and Co. to do something. You could see that very well over the summer of this year with comments made by Jack Ma saying we need to do IP better protection. And then on the other hand, saying the OEM and counterfeiters actually do better quality than the brand. So all the frustration mirroring on all the pressure put on them. And that means the online complaint systems put up by the larger platforms, they actually do start to work. It requires time, engagement, resources. You need to know how to do it, but it's not impossible, and it's one piece of advice we give to all clients to really try to use it, and to also concurrently not leave the field of distribution to the counterfeiters, but have your own shop established to directly distribute to customers and to open up your own distribution channels online, which is becoming more and more important. Online shopping is a huge deal in China. If you have a very serious infringer, tracing is very cumbersome. It's not easy. Mobile phone numbers are wrong. You have a proxy address. Goods are delivered from another address, etc. So you will need to have a very good system in place to obtain evidence and trace back to the manufacturer. And what will become an option, we believe, in the future is to sue platforms more. So while in the past suing Taobao, etc., for many reasons was not considered wise, we believe that this will change, and we have seen actions in the US already, but we will see further actions also inside China. We expect new rules to tackle this, especially also in the area of online criminal investigations and enforcements. This is also linked to the whole safety issue, control over the Internet, consumer protection. And on the other hand, we believe that the government actions will by far not be enough. So right owners, if they have a considerable amount of goods which are subject to trading on such platforms, will need to also consider software tools, and they will need to design a system specifically for China. It will not be enough just to say, we have a look and we send a cease and desist letter. It will be still a lot of work as long as customs statistics show that counterfeits in Europe, for example, almost 80% are still coming from China. But on the other hand, to conclude with that, is China is now complaining itself about counterfeits being imported into China. So this may also help to continue the government's efforts to improve at this point.
Moving topics. This is again a question for all three of you, actually. Where do you think the real growth opportunities are across the Southeast Asia region, and what are the IP challenges that may come from that? Thomas, I'll start with you.
For me, the main markets will be, of course, China, Taiwan, but also Vietnam and Malaysia will be growth markets. As consumers pick up international tastes, slowly opening up, higher quality is appreciated, purchasing power rises, and also the increasing finding of IP in some of the markets, which were previously seen as dead water, indicates in China already a race to the top. More and more IP is being created, innovation campaigns being also announced in Singapore and other countries. And we believe that, therefore, high-value goods will face new competition from China, coupled with IP, and that, therefore, the growth opportunities will be strong in these markets. Internet-related rules may slow down some of the growth for business in China as compared to the US and the EU, but all in all, I believe that these markets still are promising in spite of decreasing growth rates, which have been double digits before and now should be around, realistically, 5 to 6%.
Jonathan?
I think the real growth area would be in relation to data protection and privacy. With high usage of mobile devices in the Southeast Asian region, collection, protection, and use of personal data has become a real issue. But if you look at the Southeast Asian countries, to date only a handful of these countries have introduced data protection and privacy laws. So whilst they are actually, as we discussed earlier, they are grappling with the basic IP laws like copyright, trademark, patents, and so on. But the technology has moved on to the online space, so they do need to look into introducing personal data and privacy laws. And in those countries that have introduced personal data protection laws, they have generally taken a light touch approach and have not rigorously enforced the personal data protection laws. So our personal data is still being exposed to potential abuse by data collectors, and I think this is a real IP challenge in the online space here in Southeast Asia.
Okay, and Pavini, finally?
Yes, actually, there is growth in all across Asia in general, I would say, but potentially higher growth in the countries such as Malaysia, Cambodia, and Laos. These countries are rich in natural resources and they developing fast. So the challenges with fast development is, the inbound of the counterfeit products into the countries. And the local regulatory bodies should be fast in putting in place all the measures to combat the flow of these counterfeits. Other challenges are, I would say, various internal issues that must be addressed by local governments, such as lack of adequately trained human resources. The counterfeit products are being very sophisticated and quite advanced in technology these days. So catching up all these, technology is being a major challenge to various government authorities, where if they are not adequately trained and the staff are not fully aware or able to identify or find solution of this problem.
Thanks, Pavini. Then I wanted to turn to some really sort of overarching and practical advice from all three of you. If you had to give a few pieces of key advice to business expanding into this region, what would it be? And I'll start with Pavini on this one.
In my view, I think because there are not many countries in the region that English that have English as an official language. So I would suggest that before expanding the business into the region, maybe you should find a good local partner who can assist with this language barrier, as well as they might be able to assist you in getting the right kind of protection, building the relationship with the market as well as the government authority. And the second one would be ensure to register your IP rights in the respective country before expanding into the new region. Yeah.
Thank you. Thomas, then?
I believe 3 points which are important. The first one, old rule, know your own cash cow and file for related IP rights as early and as broadly as possible. Secondly, build up a consistent distribution system. Use licensing, which is becoming more important. Protect your value chain. And the third one is monitor the market and know it better than you do now to enable yourself to adapt your strategy. Lack of intelligence, lack of good advice is often the reason for problems later on occurring.
Okay, Jonathan, finally.
Right. I would say, clients should take steps to protect their IP in the countries that they intend to expand into before they even begin to talk to prospective partners, whether these are joint venture partners or distributors in those countries. And they must be mindful that the registries in some of the Asian countries they're not as efficient as those in the developed countries. So they must manage their expectations and expect a longer time period before they get their IP registered. So it really is imperative that they start the process early and not wait until they want to enter the market and then start thinking about registering the IP in these countries. So start early and file the applications as early as possible.
Thanks, Jonathan. Thank you for all the questions that have come in. There's one I think I will try and squeeze in if I may. So there's a comment. It's interesting to see Thailand and Indonesia so close together. I assume that means in the overall rankings where they're 28th for Thailand and 30th for Indonesia, so close together. However, the disparity on the ground as regards enforcement action is vast. I understand there are some 5,000 trademark raids per year in Thailand, and in Indonesia around 50 cases in total as regards IP infringements. Such disparity doesn't seem to be reflected in the index. Any thoughts as to why? Just to give my initial thoughts, I know that Indonesia scored relatively well on copyright. So, I mean, in the overall rankings, of course, reflects all the IP rights. So Indonesia had some amendments to its Copyrights Act, which I think probably would have helped bring it up, although it still scored lower than Thailand in copyright. But I just wonder, we don't actually have someone from Indonesia in the team at the moment, but Pavini, do you have any thoughts on this, any comparison between Thailand and Indonesia on there and the number of raids? The 5,000 is a good number in Thailand.
Yes. I would say it might probably of the government now they focusing on all this, counterfeit problem, nowadays. So that's why they have the policy, to focus on this. So that's why it's bringing up all these, figures, I would say.
Okay, well, if we have further thoughts on that, we're more than happy to send them through to those asking the question. We will follow up with other questions separately by email if we may. Thank you for those who have submitted questions. We'd be very grateful for feedback on this webinar. Please do that using the survey button which is in the system there. Meanwhile, a recording of the webinar will be available on our website. Please do have a look at the full GIPI 5 report and use the interactive maps, both of which are on our website. There are links to these if you click on the green resources button on in the webinar. If you prefer to have a hard copy of the GIPI 5 report, please let us know and we can send it out to you. And we welcome all questions and feedback on GIPI 5. Please email that to Taylor Wessing, either your Taylor Wessing contact that you know, or to myself, Roland Mallinson, at the email shown on the slide here. That just leaves me to say thank you on behalf of Thomas, Pavini and Jonathan. Thank you for listening and goodbye.